Is right to property a fundamental right or a constitutional right? Everybody who read Lakshmikant would have answered this question, but why was it changed? The understanding behind this is important because 44th Constitutional Amendment Act of 1978 has always been a repeated theme in our previous year questions of polity. Let us understand. Democracy as a form of political arrangement is nothing but individuals are treated equally. These individuals surrender their power through voting to the state, and state in turn gives them security and welfare. This is the social contract in a democracy. Now, when state is getting such power, it is quite possible that it can stamp its authority by sidelining the minimum requirements of individuals. Now, what are those fundamental requirements every individual will have because of his nature as a human being? Those are quantified or listed in the part 3 of our constitution under fundamental rights. So, in simple words, if fundamental rights which are there under part 3 of our constitution are changed by the government, that will not stand in Supreme Court. This is given in the basic structure doctrine of the Keshavananda Bharati case also. Now compare that with Article 326, for example. It is a constitutional right, right to vote. Where is it mentioned? In the constitution itself. But you can see that in 1949, the age at which every person can vote is 21 years. After a few years, after the 61st Constitutional Amendment Act, they reduced it to 18 years. They changed it. This ability to change means that it is not violating the basic structure, it is not fundamental to the human existence. So the basic difference between a constitutional right and fundamental right is this ability to change the law. It can be something else at the time of initiation of the constitution, and by the virtue that we have through Article 368, which gives us the flexibility and also the rigidity, we change the laws in tune with the accordance of the time. But certain laws can never be changed, like right to equality, and therefore they're called fundamental to human rights and human existence. So this is the basic difference between a constitutional right and a fundamental right. Now let us see why right to property is a constitutional right and not a fundamental right. At the time of independence, that is in 1947, 75% of the population depended on agriculture, and in India more than 50% of the land is under agriculture. But the problem is, there was an existing system back then. We have read in modern history about the zamindari system, and majority of the land is held by these zamindars traditionally, and the common people who were also depending on agriculture did not have any right to property. In this regard, in our Constituent Assembly, our constitutional forefathers were faced with a dilemma. Should we give right to property considering the severe inequalities that were existing in our economic system, which is predominantly based on agriculture? After a lot of debate, it was settled that indeed right to property should be secured. Finally, under Article 19, we did adopt right to property. After the commencement of the constitution, it's quite obvious. I mean, like after 250 years of British rule, obviously the government would want to carry out land reforms. Why? To reduce inequality. But Article 31, what does it say? It is under Constitution Part 3, that is fundamental rights. So, no person shall be deprived of his property save by the authority of law. That is, if laws are made to take away the property of people, it can be directly questioned in the Supreme Court itself. Now, when the government, especially in the state of Bihar, for the first time, tried to carry out land reforms by taking the land of zamindars, and Patna High Court said that this is against Article 14, that is right to equality. You cannot deny that zamindars their ownership over land because it is against right to equality. So this is a sort of a narrow interpretation of Article 14. Realizing this, the government came up with the first Constitutional Amendment Act and inserted this Article 31A and said if the government decides that certain reforms should be taken up for agricultural benefit, it is valid under Article 31A. So, is everything fine now? Not really. If you take a look at the original constitution, that is Article 31, there is this authority of law clause also. So, as a part of that, Article 31 clause 2 says that if the government decide to take away the land, they should also give compensation. So, this compensation is based on what principles and how much? This became a matter of debate. So in response, the government came up with the fourth Constitutional Amendment Act and said that once the government decides a certain compensation, the parties cannot question that in a court. That is to say, it is not justiciable. But still, the problem is this compensation was again a matter of debate. The word compensation itself was a matter of debate. A lot of cases came to the court saying that the government is not paying them adequate compensation. So this whole thing turned out to be a roadblock for the government's objective. The government, having understood that the major reason for all this litigation is because of the existence of the word compensation in the law, decided to go ahead with the 25th Constitutional Amendment Act in 1971. What did it do? It replaced the word compensation, which is subject to judicial review time and again through one clause or the other, and they substituted it with the word amount. Now, when you say amount, this word cannot be debated in the court of law. Therefore, the government thought the problem was resolved. Yes, even the Supreme Court in the Keshavananda Bharati case upheld this particular Constitutional Amendment Act, but it also set two particular criteria to question the validity of such laws. One, if the government is not clearly mentioning the principles by which the amount which is to be given to the person who is giving his property is not clear, then that person can again file a case. Secondly, if the compensation given is unreasonable or if it is not in accordance with the principles, then again the person can file a case. So finally, the 44th Constitutional Amendment Act in 1978 removed this fundamental right from part 3, that is the right to property, and placed it under Article 300A, which says that nobody can be deprived of property except by the authority of law. So what is the implication here? When we are talking about the concept of state, or in simple words government, there are three branches: legislature, judiciary and executive. Now after the 44th Amendment Act, Article 300A became a constitutional right from being a fundamental right. Now what does this mean? This means that Constitution ensures protection against arbitrary action of executive. That is the meaning of constitutional right. But if it is a fundamental right, it is an arbitrary action of state, and directly through Article 32, a person can go to a Supreme Court. This is the difference between a constitutional right and a fundamental right. So Article 300A ensures that a government officer cannot harass an individual. But if state can make a law and justify all its principles, and it stands the test of judicial scrutiny in the courts, such a law is valid. A person cannot say that I have a fundamental right to my property and state cannot take it away. So this is the difference between constitutional right and a fundamental right. I hope this important topic is clear, and this is a very often repeated theme, that is the 44th Constitutional Amendment Act of 1978. If you like this video, please like, share and subscribe, and switch on the bell icon for more such updates.